A Supreme Court decision just dropped, 9-0, no disagreement, that completely changes how police can use force when they discover you're carrying a gun. If you own a firearm or carry concealed, this ruling could be the difference between justice and a cover-up. Subscribe right now because this affects every armed American, and the mainstream media is barely covering it. The ruling that changed everything. May 15th, 2025 marked a turning point for gun owners across America. The United States Supreme Court issued a unanimous decision in Barnes versus Felix. 9 justices, 0 disagreement, spanning the entire ideological spectrum. When conservative and liberal justices agree without a single dissent, you're witnessing something extraordinary. The last time the Supreme Court reached unanimous agreement on a Fourth Amendment use of force case was over a decade ago, and that decision reshaped police training nationwide. Here's the core issue. For years, 4 major federal appeals courts used a legal standard that essentially put blinders on judges reviewing police shootings. These courts, covering states like Texas, Louisiana, Mississippi, and others, applied what's called the moment of threat rule. Under this standard, if you were shot by police, courts could only examine the final split second before the trigger was pulled. Your legal carry permit? Irrelevant. The officer's contradictory commands can't be considered. Whether the officer created the dangerous situation himself? Not allowed in the analysis. According to FBI data, there are over 20 million concealed carry permit holders in the United States. Add constitutional carry states, and the number of Americans legally carrying firearms on any given day is staggering. Every single one of these individuals is one traffic stop away from having to navigate the most dangerous moment in civilian-police interaction. The case that exposed the problem. April 28, 2016. Ashian Barnes was driving on a Houston area highway when Constable Roberto Felix received an alert about unpaid toll violations linked to Barnes's license plate. A routine traffic stop followed. The kind that happens roughly 50,000 times per day across America, according to Department of Justice statistics. Felix approached the vehicle, requested license and insurance, standard procedure. Barnes explained he didn't have his physical license, and the car was a rental in his girlfriend's name. Here's where the encounter shifted. Felix told Barnes to pop the trunk from inside the vehicle. Barnes complied and turned the ignition back on, a detail that would become critical. Felix then opened the driver's door and drew his weapon. Barnes began driving away. In response, Felix made a split-second tactical decision. He jumped onto the doorsill of the moving vehicle. Picture this clearly, an officer voluntarily placing himself on the outside of a car that's starting to accelerate, hanging on while the vehicle is in motion. Felix shouted, "Don't move," twice. Then, with his head actually above the roofline where he couldn't see inside the vehicle, he fired 2 shots through the roof into the car. The entire sequence from the car moving to it, stopping, 5 seconds. The time from Felix jumping onto the moving vehicle to firing the first shot, 2 seconds. Barnes was struck and died from his injuries, though he managed to stop the car before losing consciousness. But here's the question that would reach the Supreme Court. When reviewing this shooting, should courts only examine those final 2 seconds when Felix was hanging on a moving car, or should they consider his decision to jump on that car in the first place? Why gun owners were especially vulnerable. The moment of threat rule created a unique danger for legal gun carriers that most people never recognized. Research from the Police Executive Research Forum shows that officers receive an average of just 8 hours of training on how to conduct traffic stops with armed citizens. Compare that to over 60 hours on firearms training itself. When an officer discovers you're carrying, even legally, the encounter fundamentally changes. Heart rates spike, adrenaline surges, and decisions get made in fractions of seconds. Consider the statistics. In 2023 alone, over 1,100 people were shot and killed by police in the United States, according to the Washington Post database. What the moment of threat rule meant was that in 4 federal circuits covering multiple states, if you were legally carrying and an officer's poor tactical decisions created a dangerous situation, courts couldn't even discuss those decisions. Your Second Amendment right to carry could literally be used against you. the presence of your legal firearm becoming justification for force, while the officer's actions leading up to that force were legally invisible. The Fifth Circuit's application of this rule was particularly troubling. In case after case, legally armed individuals were shot after officers gave contradictory commands, failed to use de-escalation tactics, or positioned themselves in ways that made force nearly inevitable. Yet courts applying the moment of threat rule couldn't question any of it. They'd ask one question only, at the final moment: was there a threat? If the answer was yes, even if the officer created that threat, the shooting was deemed reasonable. But the Supreme Court didn't just reject the old rule, they established something that completely flips the power dynamic. What standard did they create? The Supreme Court's game, changing standard. Justice Elena Kagan wrote the opinion, and she didn't mince words. The Fourth Amendment requires courts to assess the totality of the circumstances. Not a frozen moment, not a carefully selected 2-second window, but everything relevant that happened during the encounter. The court explicitly stated that judges cannot review use of force cases while wearing chronological blinders. This wasn't a suggestion or a guideline, it was a constitutional mandate. The court referenced its earlier decision in Plumhoff versus Rickard to illustrate the principle. In that case, a suspect led police on a high-speed chase exceeding 100 miles per hour for over 5 minutes, endangering countless civilians. When officers finally shot him, his family argued the shooting was unjustified because the immediate threat had passed at that precise moment. The Supreme Court rejected that argument, explaining that you cannot evaluate the reasonableness of force by ignoring the 5 minutes of reckless driving that preceded it. Now, apply that same logic to Barnes versus Felix. Officer Felix jumped onto a moving vehicle, a decision that created immense danger for himself. Under the old rule, courts had to ignore that decision and only ask whether Felix faced danger while hanging onto the car. Under the new standard, courts must ask, did Felix's decision to jump on the car create the very danger he then cited as justification for deadly force? For gun owners, this shift is monumental. It means an officer can't see your legal firearm, make a series of tactical errors, or give contradictory commands, and then claim the final moment of perceived threat justifies shooting you. The critical question left unanswered. The Supreme Court specifically declined to address one major issue, and Justice Kagan acknowledged this explicitly in the opinion. The question: can an officer who deliberately or recklessly creates a dangerous situation then claim justification for using deadly force to escape that situation? The court said this issue wasn't properly before them, because lower courts applying the moment of threat rule never analyzed it. But by mentioning it, the court signaled this question is on the judicial radar and will likely be addressed in a future case. This matters enormously for armed citizens. Imagine an officer conducts a traffic stop and discovers you're legally carrying. He becomes visibly nervous and starts issuing commands. Hands on the wheel. No, wait. Show me your license. Actually, hands back on the wheel. Now reach for your ID slowly. Your wallet is near your holstered firearm. As you attempt to comply with contradictory instructions, your hand moves toward the gun area. The officer, having worked himself into a state of panic through his own confusing commands, perceives a threat and fires. Under the new totality of circumstances standard, courts can now ask, did the officer's contradictory commands create the confusion that led to the hand movement? That's progress. But the unanswered question goes further. If an officer recklessly creates danger through poor tactics, does he lose the right to use force altogether, or is force still justified if a genuine threat materializes from his recklessness? How this changes police training and accountability. Police academies across the country are going to have to rewrite their use of force curriculum. For decades, officer training focused heavily on the 21-foot rule, the idea that a suspect within 21 feet can close distance and attack before an officer can draw and fire. That training emphasized threat recognition and rapid response at the moment of perceived danger. What it often didn't emphasize was tactical decision-making in the moments before that danger materialized. Barnes versus Felix makes those prior moments legally relevant and subject to judicial review. The International Association of Chiefs of Police has already begun circulating updated guidelines in response to this ruling. Departments are now required to train officers not just on when they can use force, but on how their tactical choices before that moment will be evaluated in court. This includes how officers position themselves during vehicle approaches, how they communicate with armed citizens who've disclosed their carry status, and how they avoid creating no-win scenarios where force becomes the only option. Consider the financial implications alone. Cities and counties face massive civil liability when police shootings are deemed unconstitutional. A single wrongful death verdict can exceed $10 million. Under the moment of threat rule, municipalities had a built-in defense. Courts couldn't even examine the officers' tactical failures. That shield is now gone. Prosecutors reviewing police shootings must now conduct more thorough investigations. It's no longer sufficient to ask, was there a threat at the end? Prosecutors must examine the entire encounter, including whether officer actions created the circumstances that led to force. When an officer asks, "Do you have any weapons?" what you say in the next 3 seconds could determine if you go home alive. So, what does this ruling actually change about that moment? What this means during your next traffic stop. You're driving home from the range with your legally owned firearm secured in your vehicle. Blue lights flash behind you, routine traffic stop for a minor violation. The officer approaches and asks for your license and registration. Depending on your state, you may be legally required to disclose that you're armed. You say, "Officer, I need to inform you I have a firearm in the vehicle." What happens in the next 3 seconds determines whether this encounter ends with a warning or in tragedy. Under the old moment of threat rule, if the officer reacted poorly, drawing his weapon, shouting contradictory commands, positioning himself in a way that made safe compliance impossible, and then shot you when you moved to comply, courts in several circuits would only examine that final moment. They'd ask, when the citizen's hand moved, was the officer in reasonable fear? If yes, shooting justified. Barnes versus Felix changes this calculation fundamentally. Now, if an officer's reaction to your legal disclosure creates danger, courts can examine that reaction. Did the officer follow training for armed citizen encounters? Did he create confusion through contradictory commands? Did he fail to use de-escalation techniques appropriate for someone who just voluntarily disclosed their firearm? A sign of lawful behavior, not criminal intent? The practical implication is that officers have an incentive to handle armed citizen encounters professionally and tactically sound from the very beginning. They can't create chaos for 2 minutes and then claim the final 2 seconds justify force. The totality test. What courts now review? When a court now evaluates whether police use of force against an armed citizen was constitutional, they must examine multiple factors across the entire timeline. First, the initial justification for the stop. Was it lawful or was it pretextual? Courts can now consider whether an officer used a minor violation as an excuse to investigate someone he suspected of carrying, creating an encounter that shouldn't have happened at all. Second, the officer's conduct during initial contact. Did he follow established protocols for interacting with armed citizens? Did he remain calm and professional, or did his visible anxiety escalate the situation? Third, the commands given. Were they clear, consistent, and possible to follow safely? Or were they contradictory and confusing, making compliance dangerous? Fourth, the officer's tactical positioning. Did he put himself in unnecessary danger, creating a situation where force became his only option? Fifth, the use of de-escalation techniques. Did the officer attempt to reduce tension, or did his actions heighten it? Sixth, the timing and proportionality of force. Was there an opportunity to resolve the situation without shooting, or did circumstances genuinely require immediate deadly force? Seventh, the suspect's behavior throughout. Was he compliant, resistant, or actively threatening? Courts must weigh the civilian's conduct against the officer's actions. If someone is trying to comply, but the officer's commands make compliance impossible, that matters. Eighth, the presence and legality of any weapons. A legally carried firearm, disclosed voluntarily, should be viewed differently than a concealed weapon discovered during a search. the limits, and what still puts you at risk. Barnes versus Felix is a major victory. But it's not a blank check, and understanding its limitations is crucial. First, this ruling doesn't prevent officers from using force against armed individuals. It only requires courts to evaluate that force based on the full context. If an officer handles an armed citizen encounter professionally and still faces a genuine threat requiring force, this ruling doesn't change that outcome. Reasonable force remains constitutionally permissible under the Fourth Amendment. Second, the ruling doesn't address qualified immunity, the legal doctrine that shields officers from civil liability unless they violated clearly established constitutional rights. While Barnes versus Felix clarifies that courts must use the totality of circumstances test, officers may still claim they're immune from lawsuits because the specific facts of a case don't match previous, clearly established violations. Third, the ruling doesn't eliminate the danger of split-second mistakes. Even with perfect tactics leading up to a shooting, if a situation deteriorates rapidly and an officer makes an honest but tragic error in judgment, this ruling doesn't automatically render that shooting unconstitutional. Courts still give officers some leeway for decisions made under extreme stress. They just can't ignore the officer's role in creating that stress. Finally, and this is critical, the ruling only helps you if your case gets to court and is decided on the merits. If you're shot and killed, your family has to file a lawsuit and survive multiple procedural hurdles before a judge even applies the totality of circumstances test. Now that courts examine every moment of the encounter, what specific actions during your next traffic stop will make this ruling work in your favor? This unanimous Supreme Court decision just strengthened both your Second and Fourth Amendment rights in ways most gun owners don't realize yet. Your constitutional protections during traffic stops have fundamentally changed. Hit subscribe and turn on notifications because these legal updates happen fast. And staying informed isn't optional. It's essential for every armed American.